Next on the calendar is number 87, People versus Perry C. Griggs.
Good afternoon, Your Honors. Alan Williams of Legal Aid for Mr. Griggs. May I please reserve 2 minutes for rebuttal, Your Honor?
You may.
Chief Judge DeFiore, thank you, and may it please the Court. What happened in the proceedings below should not be tolerated. First, the prosecution having done so much to deny Mr. Griggs fair process, the prosecution should not be permitted to prevail. And second, defense counsel having done so little for his client at an important stage of the proceedings, he should not be given even the mild compliment of a ruling that his performance met professional expectations.
Why shouldn't the defendant have to preserve these claims? I mean, they're significant claims.
Well, with respect to the ineffective assistance claim.
Let's talk about the substantive claims first.
Certainly, Your Honor.
That was the direction of my question.
Certainly, Your Honor. With respect to the issue regarding Jasmine Greer, the prosecution misrepresented to the defense that the person the defense had requested to have testify.
And it appears that defense counsel had some inkling or some knowledge about that, and there was some discussion being had, and then counsel was relieved.
There was some discussion about the issue. I would note, Your Honor, that in the first place, the record does not indicate that the prosecution ever, in fact, got back to the defense with respect to this. When Mr. Griggs elected his right to represent himself, the issue that he raised was specifically regarding the grand jury instructions, one of those two issues and not the other. In the prosecution's statement that was taken from Greer, there was, and given to the defense on the first day of jury selection, there was no discussion whatsoever about this grand jury matter. The prosecution having misrepresented to the defense that this person testified before the grand jury.
And once counsel was relieved, what prevented the bringing of that motion?
Well, for one thing, the motion, there isn't any indication that the defense was, in fact, aware of that issue, because the defense was not told, as far as the record indicates.
Was the defendant present at the discussions?
Well, he was party to discussions, the contents of which the record does not disclose. It was mentioned on pages 84 and 85 of the appendix that defense counsel, the prosecutor, and Mr. Griggs were present for discussions regarding the testimony of Jasmine Greer and the cautionary instruction, if any. Now, it's possible that the phrase, the testimony of Jasmine Greer, indicates counsel may have still thought, in fact, she testified, maybe not. It does seem that at least this issue is at least arguably flagged in some way, which certainly is why defense counsel should have raised it. But specifically with regard to preservation, if the people having violated the requirement that they notify the grand jury of the request to have this person testify, and then compounding that problem.
Is there anything in the statute that says how that should be communicated or by whom?
The statute says that the defendant may request either orally or in writing, but it cannot be that because the statute provides for that, therefore it was, as has been suggested in the People's Brief, Mr. Griggs's burden when he made his appearance before the grand jury to say, by the way, grand jurors, I'm repeating the request that was made in writing. And the reason is that there is no way to apply the statute such that the means of notifying of submitting the request to have someone testify varies depending on whether or not the defendant exercises the statutory right to testify. And the people have conceded, both at the appellate division and in this court, that the prosecution erred by failing to convey to the grand jury the request to have Greer testify.
Have we ever dispensed with the requirement of preservation in a grand jury?
I am not aware.
Matter?
I am not aware that this court ever has done so. However, because of the very unique and fundamentally serious aspects of this particular issue, this should not be treated as any ordinary case. It is so important to a defendant to be able to have somebody considered to testify before the grand jury on his or her behalf.
Well, didn't we recently say that the defendant, him or herself, doesn't have the right to testify before the grand jury, that that's a decision that can be made by counsel?
Yes, in People v. Hogan.
So if we held that, why would this be a greater right than that?
Because the importance of having somebody who is not the interested party is something that is considerably more valuable than the defendant saying to the grand jury, I who may go to prison.
Here, Greer was mentioned in the grand jury proceedings. So certainly if the grand jury had wanted to hear her testimony, they could have requested that themselves.
Absolutely, but I would make a couple of points about that. The first is that I'm not aware that grand juries are particularly activist in trying to say, okay, this other person, let's hear from this person. But regardless of that, the prosecution is required, absolutely required, to notify the grand jury of that request. And as the people conceded, they erred by not engaging, by not conveying that request to the grand jury.
And is that a per se error? I mean, should we look at what on the record it indicates she would have said?
It is per se error, I believe, with regard to the issue of whether it per se warrants dismissal of the indictment. I would say a couple of things about that. The first, yes, and in the alternative, even if not, it is a cumulative impropriety issue, because it's not just, in the first place, you know, the appellate division said, well, what was her value? She wasn't there. That's the point. Hewlett said she's right there when the gun is pulled. So this would be something that would affect the grand jury's determination of the credibility of the witness.
As I understand that, and we put it aside, she says, I got out of the car and I didn't see anything twice. But putting that aside, yeah, so you want us to look at that in conjunction with the other two errors, which are clearly unpreserved. I mean, he has defense counsel in the room with him when he's testifying in the grand jury, and he's shackled, and this questioning is going on, right?
Yes, which all the more makes it incredibly inexcusable that counsel did not raise any of these issues.
How do we look at the ineffective assistance claim through kind of the lens of the fact that he, one, then says, I want to go pro se, he gets another lawyer first, then he does go pro se, so which counsel are we considering as ineffective in that sequence?
In particular, the attorney who represented him at the omnibus motion stage, it really would not make all that much of a difference whether or not the second attorney is added, having served so briefly. But the point is that the indictment would have been dismissed before he even exercises the right to go pro se if only counsel had made this right. Counsel took 8.5 months to file this short, boilerplate, lousy omnibus motion that raises none of the good issues, raises an issue that is absurd, a Wade issue, in a case where the defendant's testimony already took Wade out of the case completely. How did it take 8.5 months to file a motion of this sort? The indictment would have been dismissed had counsel made that motion, and if it hadn't been, it would at least have guaranteed Mr. Griggs' appellate review of the issue. There would have been, he would not have had to go to trial with this horrific defense that he performed on his own behalf, and aside from that, he would have at least been able to obtain review of the problems in the grand jury
Do
proceeding.
you know, is it anywhere in the record, was there a security officer in the grand jury?
I don't recall, Your Honor, but the record does indicate that Mr. Griggs was shackled when he testified and that the cautionary instruction indicated that his condition was relevant to the credibility assessment.
That was the cautionary instruction said it was relevant to the credibility?
Because what the cautionary instruction said was that the custodial status should not be considered for propensity or anything else beyond the fact that he testified and it's your duty to evaluate his credibility. Not only, I apologize, Your Honor, not only does that not cure the taint of having him appear in a robbery case in shackles before the grand jury, it actually suggests to the grand jury affirmatively this affects whether you should believe that he's telling the truth.
Thank you, counsel.
Thank you.
Counsel, what's the procedure that's to be followed when a defendant is required to be shackled before a grand jury?
The people are required, Your Honor. I'm sorry, may it please the Court, Michael Hillary for the people. The people are required to set forth a rational basis on the record to justify a defendant's shackled appearance before the grand jury. And we would concede that there's no indication in this record that that occurred. So defendant was improperly.
How often do defendants or witnesses who are potential defendants appear shackled before grand juries?
I'm sorry, Your Honor's question, how often do they appear shackled?
Is this a common occurrence?
I really don't know how to answer that question, Your Honor. I know that we've had cases in Erie County. I mean, this is certainly nothing that appears in the record, but we have had.
That's because the grand jurors didn't seem to react to his shackling, as if this might be a regular kind of occurrence.
Well, and I think, Your Honor, that may be a testament, at least partially, to the cautionary instruction that was delivered to the grand jurors as to how they were to approach the issue of his being shackled before it.
Was the supervising judge, the judge who supervised the grand jury, was he or she consulted?
Concerning the shackled appearance, I believe it was after the fact, Your Honor. I don't believe it was done as it was supposed to have been done here.
So who made that determination that this defendant needed to be shackled before that grand jury panel?
Well, I believe that would have been, I know that he had a pending charge, so it would have been made by authorities in conjunction or with the knowledge of our office, and nothing was done to establish why on the record for a judge.
As I think we discussed when this leave application came up, this, when you look at the facts of this, when Mr. Hewlett, I mean, the defendant paid him to be a cab driver and to drive a certain distance. Hewlett decides he's 7 minutes short or something, and now the defendant's girlfriend has got a problem, and that leads to this thing. The idea that this was a robbery, and the only one that says he had a gun was the cabbie, raised questions in my mind. I thought there's a real question of fact here as to whether or not the guy just said, I want my money back, and took it, which would make it kind of a breach of contract, I suppose. But given that, and I appreciate your candor in the fact that the cross-examination was inappropriate, he was shackled, he wanted his girlfriend to come and testify, which I thought would have been fairly significant in terms of exactly what happened. None of that happened. You concede that, but you say it's unpreserved. And I wondered, what do we then do? Does that mean that we can a 440 would seem to be logical, but you've already conceded it all. And so I don't know where this goes, but it just seems to me at some point, you know, this gentleman didn't seem to get a fair shake.
Your Honor, that actually takes me to the prefatory remarks that I struggled to come up with in preparation for this oral argument, because I want to make it clear I in no way intend to be an apologist for the errors, in particular the omission that Mr. Williams very artfully presented to this court concerning the prosecution's failure to rightly handle the request by a defendant that a witness testify on his behalf before the grand jury. These are omissions that I can't defend. I would like to address the merits of these arguments as the appellate division did with respect to two of those issues, namely the shackling of defendant before the grand jury and the omission with respect to the request by defendant to have a witness testify. I don't want to hide from the merits of this. And with respect to those, I would say, and in particular Your Honor's concern about Ms. Greer's testimony and how that may have helped the defense at the grand jury stage, I think the circumstantial evidence is overwhelming that it would not have helped the defense. I would note the fact that at trial, the defendant did not call Ms. Greer to testify. So one questions the utility or value of her testimony in light of that fact alone. But secondly, as Your Honor indicated earlier, she had given two statements, one in June of 2010, one in September of 2011. In both of those statements, she indicated that she departed the scene as the argument intensified between Mr. Hewlett and defendant, demonstrating, acknowledging that she was not there for the entire encounter.
So your position is, had she appeared in the grand jury, she would have been confronted with this material to impeach her, and it wouldn't have helped defendant? That
is correct, Your Honor. Yes. So I think on the merits, I think it wouldn't have changed the result had Greer testified. She could have hurt herself. Had she testified, I was there the whole time, she undercuts herself and, by extension, defendant by virtue of her prior two statements. If she said,
I looked at some of that and thought, you know, we don't know what she heard and what was said. We don't, you know, when she was there. In other words, did Greer just say, or Griggs just say, give me my money back because you didn't do it, and that was it. Or, anyway, I did a lot of speculating.
Well, Your Honor, just taking these errors in totality, I would say that it's important, as this Court indicated in People v. Thompson, to recognize the fundamental distinctions between grand jury proceedings and trials. Grand jury proceedings are not adversarial in nature. They're accusative. It's an investigatory body designed to establish preliminarily whether there is sufficient proof to justify the case going forward. That is the case here. It would have taken much more than this, I believe, given the instructions and given the balance of the prosecution's work before the grand jury to have overturned this result, especially post-conviction at this case.
Can I ask about I'd like to ask about the instruction. Also, when you observed the defendant, you did see that he was in custody. The same caution applies. That should not go to any kind of propensity to commit any crime or any kind of concern above and beyond the fact that he was testifying. It's your duty to evaluate his testimony's credibility. What's the point of that last part? Or any kind of concern above and beyond, and linking that to credibility?
I think the concern that the prosecutor is trying to convey, and maybe it's inartful, Your Honor, but I think the general concern is, look, you see that he's shackled. Don't allow this to weigh in your determinations. Don't allow it to affect your calculus here. He is
But
here
that second
testifying.
part seems to connect it directly to his credibility, and isn't before the grand jury, since Greer is not testifying, the whole issue turning on whether or not they believe his version or Hewlett's version.
And I think that's
And when
why.
you're saying, okay, so maybe you don't have to look at the fact that he's shackled to show propensity, but then you've got this second part that says above and beyond the fact he's testifying, and you have to figure out credibility. I don't understand the point of that, other than perhaps to undercut his credibility, which is what really is the whole case depends on before the grand jury anyway.
And I think that's an example of how, I guess, a cautionary instruction can be interpreted as detrimental if it's not properly worded. I think that the jury got it here, and I think that can be seen by virtue of the questions that the jurors asked, especially during Mr. Hewlett's testimony. They asked, for example, about whether or not Ms. Greer was present the whole time. They asked elsewhere about the 911 tape, whether the gun was found.
But isn't the point that seeing someone shackled has a significant impact on the observer that perhaps is not so obvious in these questions that they're asking, but it has immediate impact, and this particular instruction is connecting it to credibility. It's, of course, the obvious type of impact. You just can't trust this person, they're dangerous, and so forth.
Well,
Let me ask this. When would it be error when someone comes in shackled?
Well, if there's no instruction, no rational basis, no instruction, I think that's a problem. I think the
So
result
no
there.
instruction versus a perhaps instruction that points to credibility is really what's the error?
I don't believe there's any particular litany that the prosecutor is supposed to deliver in a case where there's a shackled defendant. But the general purpose of it is to ensure as much as possible that the juror will not be swayed by his appearance and will not view it as a propensity to commit a particular crime and indict before they've heard any
So what
proof.
would disincentivize an ADA from doing this again if all they have to do is get up and give an instruction, and this one's not a very good one?
Oh, I agree, Your Honor, that the disincentive here is not what it ought to be if a defendant can appear shackled and there's no rational basis. I think, however, that the court has to look at the impact of the error.
Well, you look at that with the question that you're under indictment already, aren't you? Isn't that what the prosecutor asked when he was testifying?
I'm sorry, Your Honor?
Didn't the prosecutor ask if he was already under indictment when he was testifying in front of the grand jury?
I don't think I'm understanding your question. He had a pending case when he was testifying before the grand jury. That was.
And didn't she bring that out, that you were already under indictment?
Oh, I'm sorry. The cross-examination. Yes, Your Honor. That was a breach of the attorney-client relationship. However, as we argue in our brief, it didn't go to the substance of the crime, didn't mention the crime, and certainly wasn't intended or didn't appear intended to elicit facts that could have been used in the subsequent prosecution for another crime. So, yes, it was improper. We acknowledge that it shouldn't have happened. But, it wasn't a preserved argument, number one, and number two, the impact of it, given the proceedings as a whole, I think is marginal if there was.
What else would the lawyer have had to have done for this to be ineffective? I mean, these are three significant errors that might very well have resulted in no indictment. So what else, in your mind, would this lawyer have had to have done? What gets you past the hump that this is actually ineffectiveness?
Well, I think, again, taken as a whole, for example, the shackled appearance, no cautionary instruction. I mean, there's some dispute, legitimate dispute about whether that was the best possible instruction to give. But take away the instruction, clearly there's a problem. With respect to the breaching of the attorney-client relationship, had there been questioning concerning the substance of the crime, and had the questioning been prolonged, it wasn't here, it was brief.
But aren't you doing exactly what our precedent says you don't do, which is cabining each of these particular errors as opposed to looking at the totality of the representation? You've got these kinds of significant errors in their totality. Isn't that ineffectiveness?
totality meaning the totality of the grand jury proceedings, whether or not viewed as a whole, there's a
Representation with
pervasive...
respect to the grand jury proceedings, I agree with you there.
Right. I don't think, Your Honor, and I think the standard here is with respect to the misconduct, whether it shows willful bias, it's pervasive, it clouds the entire proceedings. Now, there were 3 errors. I can't give a number as to how many errors would be the tipping point. But when you look at these errors, in combination with the fact that defendant testified, the prosecutor really let defendant go on at length, showed due respect and regard for the defendant's right to testify and present his case, gave a cautionary instruction with regard to the shackling. The prosecutor here expressed or indicated a concern for the integrity of the proceedings. Not reflected in those particular errors, perhaps, but as a whole, the prosecutor, I think, did well enough here.
Thank you, counsel.
Thank you.
Counsel?
Thank you, Your Honor. A few quick points in rebuttal. It's up to the grand jury to decide what the weight of the various credibility issues with the witnesses would have been. Yes, it is necessary for us to discuss what the grand jury could have rationally decided based on this, that, and the other aspect of the witness's testimony. It's up to them ultimately to decide whether or not it's credible. We cannot say that the combined errors, the multiple errors in their totality, did not even pose a risk of prejudice to the defense, and that's all that need be shown, that it be a risk of prejudice in order to warrant dismissal. With regard to the shackling issue and the Greer issue, I would have to say that a 440 would not be possible at this stage because under CPL 440 point, I think it's 10 sub 2A, if it's decided on the merits by the on appeal against the defendant, then it becomes barred from that. I really think that for my client, this is it. With regard to the grand jury asked Mr. Hewlett questions that it is submitted did indicate some question about his credibility. They were asking, the prosecutor conveyed questions, saying the only time that you discussed that there wasn't enough time left, that there was going to be an additional charge when it was just you and her on the return to where she wanted to go? Correct. And that's 2 questions on page 28 of the appendix. They're understanding that this is not, apart from the burglary conviction, this is somebody who is of questionable honesty. With regard to the question about the pending indictment, with regard to Mr. Griggs not calling Greer to testify at trial, a couple of points about that. The issue is whether she, in fact, would have helped the defense. And furthermore, he couldn't disinfect the grand jury proceedings taint by not calling her at trial. We have statements. They indicate that she would have, in fact, provided some value to the defense. If he did not accept that, he was wrong. Now, it may very well have been that the later of the 2 statements dissuaded him, thinking maybe he was thinking that, well, she turns out not to be so good, in a statement 14 months and change after her original statement.
Was he pro se the whole time during the
No, he
trial?
was pro se starting August 2011. At the time that the omnibus motion was submitted in April 2011.
I mean at the trial.
Oh, I'm sorry, trial. I apologize. He was pro se. He had a legal advisor only.
Thank you, counsel.
Thank you.